Everyone. We'll now call the Wednesday, August 5th meeting of the Planning Commission to order at about 9:05. Miguel, are we? Does the general public have all the connectivity information that they need? Are we good to go?
They do, and they have everything is working fine, and also live stream is available.
Great, okay. So if you're watching from home, we are sitting with a full board today. There are 3 commission members present, and the other 2 are calling in by phone. So with that, we'll go ahead and start. We have several decision summaries to go through, so we'll go ahead and start with that. First one is our Wednesday, May 20th decision summary. We'll start with that. Is everybody ready?
I'm ready, but I have a blanket comment to make.
Okay. You want to start with that, or?
And I'm just very disturbed. I'm concerned and very disturbed that the decision summaries don't mention the concerns related to the trackside development and raised by the commissioners in our 3 very important meetings, May 20th, June 3rd, or June 9th meetings. I was under the impression that legal counsel or someone would be providing some summary on this very important matter so that the county council would be apprised of our concerns raised. I attended the county council meeting where this was raised as an issue, and I found that they were not apprised of our concerns. I went to the meeting unprepared. I made some quick comments, which I didn't feel were very thoroughly thought through. I was a little taken aback that the county council didn't have information from us on that. As such, I'd like to work with the commissioners and staff to submit such a summary for review by the county council in advance of their August 11th meeting that accurately reflects the discussion we had and the concerns we raised. I say this because when I was reviewing those 3 decision summaries that we were given just this last Friday, there were 3 meetings that took place over 10 hours, and there are hundreds of pages that are referred to in a link. Honestly, I probably spent, I don't know how many hours I spent preparing for this meeting, reviewing the current matters at hand, and just did not have the time to review meetings that were over 10 hours of meetings and very important reflections in that. So I'm going to ask for more time to review the decision summaries because I'd like to go back to those court reports. I went through the pages. One had 123 pages, another had 149 pages, another had 82. And I think in 5 days' time, it's just very difficult. And I even asked for the packet in advance because I was leaving for a few days, and I took that with me.
Chip, this is Bill. Are we still connected?
I wasn't on.
Okay. So Lisa didn't have her mic on, but in general, I think the concern is, well, I'll let her state her concerns now. She wants to start over. So one thing, what I did, the feedback I have gotten is it was hard to hear the commission members at some time. So we will pull the mic in rather close. Is that correct, Miguel? Try to get.
That is correct. And
Yep.
the other thing I just wanted to remind commissioners is if you see or staff, if you see a green light blinking or the green light off, then that just means it's out of batteries. Just raise your hand, let me know, and we'll get you a new mic.
Okay. So Lisa, sorry about that, but we'll go ahead and start.
No problem. I just wanted to say that I'm very concerned and disturbed that our decision summaries do not mention the concerns raised related to the TRAPS lakeside development and raised by our commissioners in our May 20th, 3rd, or June 9th, May 20th, June 3rd, or June 9th meetings. I was under the impression that these summaries would provide information on the very important matter so that the county council could be appraised of our concerns raised. I understand the staff has a lot going on. I understand COVID has thrown us all for a loop. But this is a super important matter, and I think it's essential that we do this right. As such, I'd like to offer to work with the county commissioners interested and the staff to submit a summary for review by the county council in advance of their August 11th meeting that reflects accurately the discussions we had and the concerns we raised. I attended the recent county council meeting and was a bit taken aback that they had no idea the concerns that we raised in these 3 meetings. And I had brought my information with me and made some very quick comments because I wasn't prepared to actually speak at that meeting. But I took the opportunity to do that because I thought it was necessary. And I just asked Chairman, Council, fellow commissioners, and Office of Planning and Zoning staff to consider this because I think it's a very, very important matter.
Okay. I have no objection to that.
This is Bill. Lisa, I agree with that, and there's some historical background that in the past we had very clear evidence that some members, but by no means all of the members of the county council, would read every word of our decision summaries, and they were very aware of that, and so they sometimes would bring us up when we were talking to them about they knew it better than we did, and so I think that's a good thing that they would know that, and on the opposite side, it's bad that not just on this crap issue, although that would be of particular importance, there are other issues that are important, and no one is going to go back and read the transcript unless it's a legal proceedings, and I think for communications we really should insist on getting the information to the county council, and I'm willing to help anybody that with your leadership to come up with on the trap issue, and hope other people will be too.
Okay. And then again, in fairness to the planning staff, maybe 2 years ago, we had asked them to summarize. We were getting literally a word-by-word description of the meeting. But again, I think this matter is a little bit different when it refers to this transcript. So I would suggest, if nobody has any objections, we'll let Lisa and Bill work on that along with the staff. The problem I see is the county council is going to take this up, next week?
Tuesday.
So
I've already drafted a 3-page document, but I haven't had time to go over and make that what I'd like to. I'd like to fine tune it. I'll share that with Bill and the staff, and we can work on that together. And I'll send that to you as well.
Okay. Mike, would you object to helping them with that?
No, I have no.
We're still missing some of the dialogue.
Yep. Sorry, I had my mic off. Yep. So sorry about that. So anyway, so I'll back up. So we'll do better, I promise. So Bill, I just said in all fairness to the planning staff, we had asked them to summarize the decision summaries instead of a word-by-word transcript. So what I'd like to do, if it's okay with the group, is Bill, you, Lisa, and Mike Stranahan, go ahead and work on that, and along with the planning staff. Miguel, does that seem doable?
It does. Just a couple comments. You're right, Mr. Chairman. 2 or 3 years ago, we discovered that the minutes had slowly transformed into an actual transcription of the meetings, which is not what a decision summary is. And really, a decision summary is just a summary of the decisions. And so we wanted to go to a decision summary format, but I think the middle ground that the Planning Commission came up with was it'll be a decision summary that indicates the decisions, but just a brief summary of the conversation is something that we'll do moving forward, and that's what we've done.
Right.
Usually, when the public, any member of the public that wants a full transcription, they contact us. We have the recordings, and then I think the onus is on the person submitting the request to actually pay for the transcriptions, and then they receive them. And those are always publicly accessible. In the case of Resolution 281, we had the court reporter here for those transcriptions, and so I don't know if those transcriptions are actually included in the grant list for the council members. I'm sorry, one second.
Those are online.
Oh, they are online?
They're
Okay.
online and available to the public.
Okay, that's good to know. But my one question though is the summary that you're putting together, I can't remember the vote on resolution 2 anymore.
3-2.
Is it 3-2? Is the summary the minority
Yes.
opinion summary? Okay, I just wanted to be sure that the planning commission was aware of that. That it wasn't a summary of the total conversation, but just what the concerns are raised by planning commissioners.
Right.
Okay.
Right.
Okay.
And then, you know, the flip side of that is, I would also, again, I think it's good to have the dissenting opinion, but you should also include the, you know, the majority, and it doesn't have to be a full length, but I think it should include a summary of the discussion, which I think is what you're looking for. Is that correct, Lisa?
I agree.
Agree, yes,
Yeah.
yes. And just a comment on
Yeah, it should be
the,
both sides.
thank you, yes.
Right.
With regard to the decision summaries, we had that discussion in February, and I believe when our new staff came on, she did an excellent job. That was not a word for word, and it wasn't a record of the vote. It was in between, and I think that we could go back to our February 5th notes, and we all explained at that time how good those were done.
Right.
I believe they were 5 pages for a 3-hour meeting. We had over 10 hours of discussion. There's over 300 pages of court reporter, and I've already summarized the dissenting opinion in 3 pages. So I think what we need to prepare for the county council is something that they can read, they can understand what the issues were raised, and they can make a vote. But right now, they have to go follow 5 links. I probably spent 5 hours just trying to put it all together in my own head.
Right.
And the county council should not be expected to do that. They should be given a nice, concise document that summarizes the discussion and the major concerns that came out.
Right.
Mr. Chairman, I'm always happy to help with almost anything, but I'm not sure how available I will be this next week. My wife's having knee replacement surgery Friday, so I don't have much time probably
Okay.
to dedicate to that.
Okay.
But I'm happy to read over your summaries and thank you.
Yeah, well, I'm a little bit pushed on time this week as well, so Lisa and Bill, I would ask you to be objective to the majority decision in your summary, and I know that you will be, to raise.
I think that we ought to have if you guys could look over, I agree with the Chip that we should cover a fair balance of the points. That's what county council needs, and but you know, I think you guys, the best thing to do is try for us to do it, and then have you guys look it over.
Okay, so you're not going to put in there simply the majority was wrong in this case?
Well,
No.
Well, we're leaning to that, but you ought to check it out.
All right, so my next question is for Tony. So Tony, on these decision summaries that we have before us, can we go through the other parts of the decision summaries and hold out the section with Trapeze Holdings, or should we just wait on all of them to move forward with that?
I think you could break it down if you wanted to. It's not what we normally do, and I think all we need to do is just make it clear that, you know, this decision summary that you're approving today is to be specified items, and that it's just clear on, you know, on the top of the document that, you know, that there'll be a set
Yep, okay.
just for the
summary
record,
that goes after the other.
just for the record, I started to find things I didn't realize I'd said, and I didn't even have the time to go back and check those. So I will have additional comments to our decision summaries in other things in addition to track.
Okay, so if that's the case, then let's just hold on and do them at a later date. I'd rather, you know, maybe do them all at one time than piece back through. So how about on our July 9th decision summary, Track East Holdings was not a part of that. Do we want to go ahead with that one? Lisa, or do you want some more time on that one as well?
Give me 1 second,
Sure.
please.
No problem.
actually need some time on that.
Okay, so Paul, is sure you've been hearing the conversation. Is this agreeable to you as well?
Yeah, I'm fine with that.
Okay, so we will just go ahead and we'll table the decision summaries that we have before us, and we will move on with the agenda. So our first item is old business. Applicant is Department of Planning and Zoning, Miguel Salinas. Recommendation to the County Council on the draft Cordova Village Master Plan. Miguel?
Thank you. I believe it was on May 20th. I believe it was on May 20th. We reviewed the Cordova Village Master Plan for discussion purposes only. So we can entertain public comment on the Cordova Village Master Plan. It's my understanding we have not received. Well, actually, we did receive one letter on the plan, which I think was distributed to the Planning Commission prior, but we have not received any correspondence for this particular public hearing. So it's at the pleasure of the Planning Commission to discuss whether they want to forward a recommendation to the County Council that they support the draft of the Cordova Village Master Plan.
Okay, so at this time, I would ask if there's any members of the general public that are calling in that would like to comment on the Cordova Village Master Plan. Miguel, do we have anybody signifying that they would like to speak?
No, everybody's unmuted, so I'm not hearing anybody indicating such.
Okay, with that, let's have just a minute for some discussion among the Planning Commission. So again, we'll go through and we'll see if there are any concerns with it. So Paul, not to put you on the spot, but I'm going to start with you today. Anything on the Cordova Village Master Plan?
No, it's I don't. It's just re-echo the same thing that I said last time, that I thought it was very well done. Got the public's input. I like the results of it, and I thought it brought forward some issues that can be resolved, and it gives a nice pathway of kind of that stretch goal of what could be done, and then kind of what can be done and what could be done down the road. So I think it's good.
Very good. Bill?
I agree with Paul, and we talked about that before. I think it's a wonderful summary, and it brings up issues that are, the community had different views on, and that did it very well, and it's very clear and attractive. I think it's an excellent. The only issue that of course interested me in terms of controversy was the potential bike hike trail, which we've had a letter on, and I think the letter brings up some legitimate concerns. I think that from my perspective, I think I've said this before, on bike hike trails, that those are addressable. They may not be, but that's in the future. And the suggestion to shut down the study, which is a state study at the moment, I think is a bit premature too. So I think that the document stands alone very well, and I'm very happy that it goes forward to the County Council.
Very good. Lisa? You're good.
Yes, I have a question for you, Mr. Salinas. What correspondence were you referring to that we received on this? Could you just refer me back to a letter date, a person that wrote the letter?
Sure. It was dated February 25th, 2020 from Zach Smith from Armistead, Lee, Ruston, Ray, representing several property owners. The letter was offered on behalf of Nagel Farm Service and other property owners in that area regarding the creation of a pedestrian trail along the former railroad right-of-way, which is mentioned in the draft plan. While their comments were, while all generally support recreation, a trail in the location shown in the draft plan creates serious concerns related to interference with farming and other business operations trespass, and liability, and for these reasons, Nagel Farm and the other undersigned property owners, which I'll read that in a second, strongly oppose the creation of this trail and accordingly request that the commission amend the draft plan to remove any suggestions of support for such a trail and/or further study of the same.
Actually, Mr. Salinas, I'm okay with you not going on. I do recall that particular correspondence. A question on process. Was that already taken into consideration? It doesn't seem that it would be because this is a December 2019 draft. And if it has been, how has that been reflected? And are there any other pieces of correspondence that you're familiar with that we need to raise for the record?
Not for the record, there's no other correspondence.
So Miguel, I do have a letter dated email, May 31st, from a Barbara Perry.
Oh, that came in your packets, I'm sorry. Yes.
And it addresses more, some things as well.
And I have others as well.
Do you want my copy, Miguel?
Yeah, I'm sorry. Thought I had them on the resolution. And I apologize, I thought I had. Sorry. No, in answer to your question, the
What date is that?
May 31st, 2020. We did receive that correspondence. There's been no changes to the draft since December 2019.
Okay, so my question in the process piece of it, and I still want to come back to another correspondence that I received, is this the time to incorporate those concerns or considerations, or is that something that is the responsibility of the county council? Because I'm not quite sure my role in this particular.
So to give you guys a heads up, what I was thinking in reviewing this is, as I go through the master plan, I think there are elements that the Planning Commission is especially concerned with. And that would be in the master plan recommendations, the land use and development, which talks about creating some overlay zones for some uses where the lots don't conform and those kind of things.
Mm-hmm.
The other things in the master plan, such as village character and appearance, my opinion is that's something that the village of Cordova citizens need to come together and decide what they want. When we talk about the area where the recycle bins are, I think that's something that the town of Cordova, the village residents should say, this is where these ought to be. When it comes to street design, I think they should have input in that. One thing I would add, I know they've talked about some street trees at the intersection of Kitty Corner and Route 309. Most of the farmers in that area move machinery through there, and you come up a gentle hill where the railroad track is, and it's very important to have line of sight there with heavy machinery, tractors and combines.
Mm-hmm.
So, my thoughts are that's not the best place for street trees on that corner, just because of a visibility issue for the machinery that travels through there. But there are some other things, again, that I think are very good, but I'm not sure, if I had my wish, we would forward this to the county council, recommend that they adopt it with the idea that the planning commission, would take up, would consider the land development standards and the overlay zone sometime in the next 12 months, and then work with the village residents to determine these other outstanding issues. In other words, I don't, that would be my 2 cents.
Okay.
Miguel?
Yeah, I don't think we would move forward on any of those potential projects without using a community process to do that. Whether it's a potential design, however big or however small, of a potential pocket park where the recycling collection areas now, or whether it's a relocation of the recycling collection area. I think that the canopy and landscaping that is showing at that intersection that you referred to, Mr. Council, is illustrative, but I think in the spirit of community planning, these are recommendations in the master plan, but they should not be done without the consultation of the affected residents.
Right.
And I certainly would agree with that. From some email correspondence that I received that had been sent previously to selected members of the council, the planning commission. I think that there's some leadership coming out of the area, and I want to respect that, and I want to hear them. And I think that the issues were around the recycling and lack of real discussion with the county or with the residents on that, and kind of a decision moving forward. I didn't get the sense that a decision had been made, but rather the plan had laid out some options. And so I'm totally in agreement with Chairman Council, and just want to make sure that I knew what we were doing so that we didn't have to reverse something at a later date.
Sure.
So, okay, on that note.
Okay, good. Commissioner Stranahan?
I first again want to commend both the staff, all of the staff, the consultants, and the community involvement. It was really great to see the community get so involved with this. It is a great plan, which my view is the plan is more of a concept than a locked in stone specifics of what is going to go there. I guess I'm more along the lines of what Chairman Council has said, that I feel this is a really good plan or concept, but when it comes to specifics, what exactly is going to be done, whether it's trees or a pedestrian path or the nature of the village, the recycling center, that there more specifics need to be tied down in the future, but I don't believe that that's necessarily the point of our job at this moment in regard to the plan.
Chip, this is Paul again.
Yes.
I just want to say, and this is just what my thoughts on the plan are, is why I thought they'd done a good job on it, because the questions that are coming up now are exactly what the plan, in my mind, should do. Some people in the community want a rails to trails path. Some people are very nervous about it. And instead of throwing that on the community right before the project's starting, this kind of conceptual idea of what some people would like to see in Cordova is a great tool for us to start discussing topics that could or could not happen down the road. That's what I think the strength of these plans are. Instead of us feeling like something's getting dropped on us that we've never heard about before, we have this forward thinking of saying, these are some ideas that we really conceptualize that could happen in Cordova, and it gives the entire community time to look at it and say, yes, this could work, this couldn't work, or this could work with some changes. So I think the plan, in my opinion, is doing exactly what I'd like to see all these plans do, is start preparing us in the rest of the community for things that could happen, and then we can work towards putting those things in place in an orderly and correct manner.
Yeah. Paul, I agree with you. Yeah. Okay, go ahead, Bill.
This is Bill. I want to agree with Paul too, because I think that there's a number of issues there, this recycling and things like that, but especially the pedestrian path, as an example, where the consultants very nicely laid out in detail some of the pros and cons and the objections of the community on that, and laid it out. And I think that Chip, I think that it's in the future for us to bring it back to the community and try to work what's best for them and what they want. But I think as a framework, this is excellent.
Okay. Any further discussion from the commission members? Okay. Hearing none, We'll entertain a motion.
I motion that we recommend to the Talbot County Council the Cordova Master Plan for consideration, as well as to consider the discussion with leadership in the community of Cordova to affect and work through the areas and improve upon the suggestions made.
Great. Okay. We have a motion by Commissioner Gezzi. Is there a second?
I'll second it.
And we
Go
have
ahead.
a second by Commissioner Boycourt to recommend to the county council that the draft Cordova Village Master Plan be forwarded to the county council, that it does meet the goals as stated in the comprehensive plan, and that, as I understand it, we'll work with the community on those issues that are addressed in the plan, as it is just a conceptual plan to start the process. So with that, I'll ask for any further discussion. All those, I guess I asked for, Miguel, would you take the roll call?
Commissioner Boycourt,
Aye.
Commissioner Spies,
Aye.
Commissioner Gezzi,
Aye.
Commissioner Stranahan,
Aye.
and Commissioner Council.
Aye.
Motion passes 5-0.
Okay. So Miguel, I would ask perhaps that you could prepare a letter for the county council and explain to them some of our thoughts and concerns with that, so that there's no doubt that this is a first step in the process. And again, I'd ask us to consider looking at the land use in the Cordova area sometime, in the next year or so. I thought there was some really great things in there. Perhaps we could move in that direction as time allows.
I will do, and actually, once a resolution is drafted and it's scheduled for county council, they'll receive a memorandum, and I'll make sure that sentiment is summarized in there.
Very good. Thank you. Okay, next on our agenda, again, the applicant is Department of Planning and Zoning, Miguel Salinas, and this is a recommendation to the county council on a draft working waterfront overlay district. Miguel?
Thank you. I just distributed to you, I just received a letter on Monday from the Critical Area Commission staff, Jennifer Esposito, who's a natural resources planner for the Critical Area Commission. I distributed that out. Mr. Boycourt, Mr. Spies, I did email you that letter. But I'm going to,
Thank you.
since it's so recent, I just want to briefly summarize what it says in here. This is the letter that we've been looking for, which is the issues that we've been discussing with the Critical Area Commission have now turned into, they've had a lot of discussion since our last meeting on this internally, and they have provided their report back to us with their comments on the draft, and they also talked to their staff attorney as well. And what it comes down to is that they are concerned that the draft may not provide enough measures for habitat and water quality protection. If you recall in the draft, we have something called the water revitalization area, which is by local designation. A local jurisdiction can create a water revitalization area which provides certain benefits in terms of water revitalization for working waterfronts, but it doesn't have any definition of what that would entail. And so in the draft that we came up with, we offered several incentives under the water revitalization area that a property owner could achieve. For example, certain things would not be counted towards lot coverage if they provided an easement for public access as part of their site plan. Another example is that we would allow non-water dependent uses to be located in the buffer as long as it didn't constitute more than 50% or more of a structure. So the majority of the structure uses and activities on that property would have to be water dependent in the buffer. So they have been struggling, as we have, staff, with how do you balance economic revitalization with the critical area objectives of habitat and water quality protection. The critical area commission supports all three. But in light of the fact, when you look at models of water inundation, forecast models, and they looked at Tillman specifically, when you look at the forecast years of 2050, for example, and 2100, it's clear that there will be periods of inundation on the island that will put the entire island basically underwater for at least during major storm events. And so they feel, the staff feels that if we go to the Critical Area Commission with this draft, and the Critical Area Commission asks us, you're asking for the relief in these critical area standards, but what are you doing in terms of coastal resiliency? In addition to water quality and quality protection, if the county does not have a good answer for that, then the likelihood of getting those approved by the commission is pretty small. So to summarize, they support economic revitalization, but they feel that what's the point of revitalizing if in 30 years those properties along the waterfront are going to be underwater. So that is a question now that we are looking at with the Critical Area Commission staff, as well as our update to our green infrastructure plan. We will not be able to answer that question that the Critical Area Commission would pose to us in terms of coastal resiliency until we do a little bit more work through that green infrastructure plan. But in the meantime, they have indicated that they could support some limited benefits in the water revitalization area that would allow non-water dependent structures in the buffer, but only on existing buildings. And they are willing to take a look at that. The second thing that they brought up is that they feel that we have something which you're all probably aware of called a modified buffer area. So in certain areas, by action by the council, you can approve, or the county has buffer areas that are less than 100 feet. It can't go any greater than 50 feet waterward, but so we have modified buffer areas in certain sections of the county, including Naps Narrows, which I think it's a little bit over 60 feet. And in those modified buffer areas, you can have certain relaxation of critical area standards within that area between 100 feet and let's just say 60 feet. Our modified buffer area has pretty much standard language that's reflected in the Code of Maryland for that section. But they believe that if we get a little bit more creative in the modified buffer area to do two things. One is to allow perhaps non-water dependent uses in the modified buffer area, so not in the buffer. So let's just say the standard buffer is 100 feet. An approved modified buffer area is 50 feet. So between that 100 feet and that 50 feet, you could have non-water dependent uses in there. Between that 50 feet and 0 feet, you cannot. In addition to that, we could take, much like the town of Oxford has done, we could amend that section of our code for modified buffer areas to allow alternative plantings, to recognize the fact that there are certain plants, tree canopies, for example, and other plants that just will not survive due to inundation and soil conditions. And you heard about this when I had the discussion on the Mark, help me out, Lisa.
Mark Hill.
Federal Hill, is it? No, Federal.
Yes.
Federal something.
219 Federal.
Correct, thank you. Federal Hills in Baltimore. And so they recommended perhaps rather than through the water revitalization area, we have opportunities to modify our text in the modified buffer area to accomplish some things that can provide incentives for economic development, provided we continue to address water quality and habitat. The third thing they raised was that, as you know, we've added several new uses that would be considered water dependent, and they have reviewed that list. And they reviewed it also against a draft that the Critical Area Commission is developing right now of some cleanup and some clarification of what constitutes water dependent uses, and so they compared our uses with that draft. And they determined that many of the uses they could support, but there are some uses that they question, which they called out in here, such as marine contracting, marine fabrication, and marine salvaging service, because they believe that those kind of economic activities aren't intrinsic to being located on the water. And in addition, although I thought we covered every definition of any new use that we inserted into the code, they said there were at least one use, if not more than one, that we did not define. So those overall were their comments. They ended it by saying that they continue to support what we're trying to do. This has been just as challenging for them as it has been for us. And they asked that I'm looking for that section. They asked that prior to the drafting of legislation or introduction of legislation for the Working Waterfront Overlay District, that we work on these changes with the Critical Area Commission to address their concerns and their comments, not just concerns. So I know we still have to go to public hearing on this, but with that, I would the Planning Commission does have the opportunity today, if they want to forward this to the County Council with a recommendation, and you can certainly do that. The other option is you can go through the public hearing today and give us a chance to make those amendments to the draft, and then have the commission forward a recommendation at their next meeting.
It would seem to me, Miguel, it doesn't make much sense to make a recommendation to the county council this time, knowing that we've got to go back and work with critical area on some of these outstanding issues. I would prefer not to do that. I would like, however, to give the public an opportunity. I know we did get a letter from Mrs. Steen, quite well thought out, and I appreciate that. But does that sound reasonable to the rest of the commission?
To listen to the public comment?
Chip, this is Bill.
Sure.
I agree that if we, I agree with your characterization of Mrs. Steen's letter, that there are a lot of points there, some of which I think we've considered, some of which we clearly haven't been. So if it's time that we can take the time while talking to the Critical Areas Commission to go through her points and make sure that they're as best we can considered. She's been part of the process from a long time ago, and I appreciate her input and her conscience for Tillman. So yeah, I think this is a good idea to have the hearing today.
Yep. Okay. Commissioner Gezi?
I would agree.
I concur.
Okay. Paul? You on board with that?
Yeah, sorry, I thought on mute.
That's okay.
That sounds good to me.
Yep. Okay. So that being said, at this point, Miguel, do we have any members of the public that have indicated they'd like to speak to this issue today?
No one registered in it? Yeah. Anybody on the line that would like to speak on the draft of the Working Waterfront Overlay District? there is none, Mr. Chair.
In defense of the public, I went online and our website is not updated and it refers to June.
That is correct, yeah, and we'll make sure that we get that updated, but there, I mean, my overall impression is that, I think the community is just sort of, at least from the phone calls I've been getting, are just sort of ready to, they just want to know when are we going to get this thing passed. I think there are property owners that are looking to take advantage of that. But we'll make sure we get that updated as well.
So Miguel, okay, so at this point, what I'd like to do is leave the opportunity for public record open. And I would say, I don't know how long, because we don't know what the critical area is going to come back with, so can we just leave it? Do we have to put a date on it, Miguel, or?
I think, Tony, are you still on the line? Actually, he is.
Yes, I'm here.
Hi, Tony. Do we need a time certain date for public comment to close, or I'm assuming we do, but
And which item was this for?
for the Working Waterfront Overlay District, if we're going to continue public comment past today as part of the public hearing, can we take public comment into the next meeting, or do we need a time certain date to close that public comment period?
I mean, I think ultimately you do want to set a clear date, but if you're going to take this up at another meeting, then you could just leave the comments open up to and through that meeting.
Yep, okay.
Yeah.
So that's what we'll do. We'll leave the public comment open up to and through the meeting when this comes back on the agenda. And then with that, Miguel, when would we hope to have some of these issues worked out and back with critical area commission blessing?
I would fully expect that we would have an amended draft by the next meeting.
Great, that's great, yeah. So I think this is something that is important to Tillman, and I'm excited about it and would like to see it move forward. Again, we do need to look at some of the comments made by Mrs. Steen. She brought out some very good points, and we will do that. So thank you, Ms. Steen, if you're listening in for that. With that, are there any additional commission comments on the working waterfront? Okay, with that, Miguel, I guess we'll take it up again at our next meeting. So, thank you. Okay, so now we'll move on to new business. Our first applicant is Joseph Ford, the agent Susan Stockman. This is a recommendation to the Board of Appeals for a special exception for a 15-foot by 6-foot 6-inch accessory structure prior to the principal residence. Is Ms. Stockman and Mr. Ford in the room?
Yes, we are.
Okay, if you would like to come forward, we'll have you at the tables to your left. Good morning, how are you today?
I'm good. How are you?
Good, good.
Just make sure the green light's on when you talk.
It is. Thank
Really
you.
close to you.
Okay. All right, Maria, would you like to start?
Sure. Don't mind blinking.
Okay. The project name is Joseph Ford. The property owner is Elizabeth Chester and others. The applicant is Joseph Ford and the agent is Susan Stockman. The request is for a special exception for the 15-foot long by 6.5-foot wide, 1-story residential accessory storage shed on the property that does not contain a principal residence. The property address is 24246 Mount Pleasant Road in St. Michael's. Should the Planning Commission elect to recommend approval for the special exception for the residential storage structure, staff recommends the following condition. The applicant shall take all of the required steps and acquire all necessary approvals, including any additional waivers necessary required for a special exception. as spelled out in the Talbot County Code.
Very good. Thank you, Maria. So at this point, Ms. Stockman, if you'd like to identify yourself for the record as well as Mr. Ford, and then go ahead and present your case.
My name is Susan Stockman, and this is Joseph Ford, who has been my neighbor for 18 years. 15, 18.
Okay.
A long time.
There you go.
Decade and a half, if not more. Joseph's house where he was living was taken down a few years ago. It was deemed uninhabitable. He had moved into the apartments in town in St. Michael's with
Ms. Stockman, I'd ask if you don't mind, for those that, if you could pull the mic a little bit closer and speak right into it to make sure everybody can hear. Yep, no worries.
Yeah. With your mother and sister? Yeah. So he had lived in that home for many, many, many years, and also has a small lawn care business that he operates out of the shed there. He keeps his lawn immaculately taken care of, takes care of my lawn and other neighbors as well. And when the house came down, the shed still existed, and it still had his lawnmower and other tools that he needs to use and to store. It's my estimation that since the county was responsible for taking the house down, and they did that, and they at that point decided to leave the shed standing, and that a precedent was set that perhaps the shed could remain there. There is hope that sometime in the future, when the other people that are on that deed can come to some agreement. It's Joseph that's been paying the taxes on this property for all of these years. He feels ownership, and he's the one that was living there. He's still not the only person on that deed. It would be lovely, maybe at some point in the future, for Habitat for Humanity or an organization could help him build a house. But in the meantime, he's maintaining the property and is dependent on that shed. The shed was not being built, it was being repaired. And my partner and I were helping him do that, and that is when the complaint went in and the stop work order went in. So we just asked that perhaps you could be lenient and grant this exception so that he could have a way to earn some money to pay the taxes on this property and move on with his life.
Great, very good. Mr. Ford, is there anything you would like to add?
No, I don't.
Okay, great. With that, I'll ask if there are any comments from the commission. Paul, would you like to start? Any comments, questions?
I don't have anything at this time.
Okay, Mr. Boycourt?
I think this is a reasonable request, and I appreciate Ms. Stockman helping us.
Yep, great. Commissioner Gezzi?
I would agree with Commissioner Boycourt that I think it's a reasonable request, and as the staff believes the applicant has met the requirements for the special exception, I'm in favor of it, and I appreciate Ms. Stockton being here today, and Mr. Ford. Thank you for your presence.
Great.
I concur, and thank you both for coming. I think it's a reasonable request, and I'm in support of it as well.
Okay. I'd ask at this time, or if there are any comments or questions from any member of the general public. Okay, hearing none, I would entertain.
I'm sorry, one more time. I think they were, okay, now you can ask again.
Okay, at this time, I'd ask if there are any comments or questions from any members of the general public that would be calling in. Okay, hearing none, at this time, I'd entertain a motion.
I motion that the Planning Commission recommends approval of this special exception with the following condition: that the applicant take all of the required steps and acquire all necessary approvals, including any additional waivers necessary required for a special exception spelled out in the Talbot County Code.
I'll second.
Okay, we have a motion by Commissioner Gezzi and a second by Commissioner Stranahan that the request for a special exception does meet the standards for a special exception, and that the special recommendation would be to the Board of Appeals to grant the special exception. With that, Miguel, would you Take the vote.
Commissioner Boycourt,
Aye.
Commissioner Spies,
Aye.
Commissioner Gizzi,
Aye.
Commissioner Stranahan,
Aye.
and Commissioner Council.
Aye.
And that motion is approved 5-0.
Okay, so what just happened is we are going to recommend that the Board of Appeals grant your special exception. Obviously, they will have the final say with regard to that as well as the conditions. So good luck with your project. I would like to stay, and I probably should have said this on the record. I think this is a little bit different than most of the cases that we hear for an accessory structure without the principal residence being there. In that there was a house there that was condemned and taken down by the county, which left you in a difficult position. So I see this in no way as setting any precedent for some of the other requests we get. This is totally unique to the situation, and good luck with your project, and I wish you the best.
Thank you. And I'd also like to thank Andy Hollis for waiving the fees to have the privilege to be before this board, and to Chris Corkle and Miguel Salinas for their help walking me through this process. So I think I added in one of my correspondence that I have a degree in art. It's not really helpful in public policy. And this is an arduous process, and it's also a little challenging for maybe some of the people that need access to it to get to it. And I'm just recommending that maybe there be some advocacy leg to help people that maybe have needs and they feel intimidated by the process or how to maneuver through it, because it's not simple. I'm sure to you guys it's what you do every day, but the rest of us, it seems like this mystery.
I totally understand, and my hope is that the citizens that were in the situation that you came before, we have great county employees that actually care. We're very fortunate for that.
Yes.
And I think, and I know for a fact that they are there to help, and I think you experienced that, and my hat's off to all the ones involved that do that, and that's what we hope the outcome will be. So
Thank you so much.
Thank
for
you.
your time today.
Thank
I
you.
also might say thank you to Maria Brophy because she was the planner behind this. That was the first exposure I've had with Maria in this meeting, so thank you, Maria.
Thank you.
Thank you, Maria. And for planning this on for me.
Okay, so next on our agenda, applicant is Yacht Club Road LLC. Agent is Brendan Nolan. And the request is for a recommendation to the planning officer for a minor variance in the critical area. Good morning. Morning. Maria, will you be presenting this as, Lisa?
Yep, this will be Lisa.
Lisa, you're up.
Project name, site plan for minor variance on the lands of Yacht Club Road LLC. The property owners are Yacht Club Road LLC, and the agent is Brandon S. Mulaney, attorney. The request, the applicant is seeking approval of the following minor variance to expand an existing non-conforming dwelling, 679 square feet in the shoreline development buffer as follows. Number one, expand the structure by adding a second floor loft and bath. The current closest point of the dwelling to mean high water is 30.7 feet, and the resulting closest point to mean high water will be 38.8 feet. The location is 24700 Yacht Club Road. Staff comments. Areas of the application use the term replace and rebuild. The applicant was notified during the review for the certificate of nonconformity and the review for the minor variance that the minor variance process may only be utilized for the expansion of a non-conforming structure. This distinction is important. Should the building plans reveal that the construction is a replacement structure, the applicant will need to follow the rules and procedures guidelines for a variance from the Board of Appeals. The applicant has not provided sufficient information to clarify whether their proposal is an expansion or a replacement or an expansion of the non-conforming structure. The staff is requesting the applicant provide a more detailed and complete description, scope of work, of what the applicant is removing and replacing for the building codes official to make a determination prior to approval of the minor variance. Should the commission recommend approval, staff recommends the following conditions. The applicant shall make an application to the Office of Permits and Inspections and follow all rules, procedures, and construction timelines as outlined regarding the new construction. The applicant shall commence construction of the proposed improvements within 18 months from the date of the planning office's notice to proceed. The applicant shall be required to provide a buffer management plan to mitigate for the new lot coverage in the shoreline development buffer at a ratio of 3 times the new disturbance associated with this project. And we have a fourth condition to add in the staff report. Approval of the minor variance is conditioned on the project constituting an expansion of the existing structure within the shoreline development buffer. In the event that the planning officer determines that the work constitutes a replacement of the structure during the building permit process, a Board of Appeals variance will be required for the project to move forward.
Very good. Good morning.
Morning.
Good. If you could identify yourself for the record and then proceed with the case.
Sure. Brendan Mullaney with McAllister, Detour, Showalter, and Walker, 100 Northwest Street, Easton, Maryland.
And I'm Paul Bowen. My wife and I own Yacht Club Road, LLC, which is the applicant in this case.
Good morning. Yep.
So, good morning. What's before you today is a request for a favorable recommendation to the Director of Planning and Zoning to approve a minor variance that will allow the property owners, this lot is northwest of St. Michael's on Yacht Club Road, allow the property owners to expand an existing cottage within the shoreline development buffer. The cottage is 679 square feet today. It's existed since somewhere in the 1930s, so it certainly predates critical area law. And the request is for an expansion of a total 11.25 square feet of lot coverage. Property owners are permitted to expand existing legal non-conforming structures by up to 20%. What's proposed is an expansion of 1.6%, so it's very minor from an expansion standpoint. Mr. Flo is correct that I inadvertently used the term replace one time in the narrative for the application. That was a mistaken use of the word. What is proposed, what's before you, and what we hope to get approved through planning and zoning is an expansion of an existing structure that's been there since 1930. You'll see in the plans that the structure proposed sits, except for the southernmost side of the foundation, sits on the exact same foundation that is there today. As much of the existing structure as possible will be incorporated into the renovation and the expansion, but the nature of the renovation and expansion is that it has to comply with building code requirements, just like any building in the county. This is a substantial improvement as defined by the International Building Code, and we won't know until the applicant contractor starts to get into the renovation exactly what members, such as the walls closest to the water, need to be worked on, supplemented. There are areas where doors will be removed and walls will be built in. The architectural drawings were submitted with the application. We've had conversations with planning and zoning and understand and agree to and hope to have your recommendation of approval conditioned on condition number 4, which Mr. Flo just read, which is if planning and zoning in their sole and absolute determination finds that what is proposed through the building permitting process is in fact a replacement, then we understand, applicant understands that a Board of Appeals major variance will be required. This property is 2.177 acres in size. It's parcel 16 of tax map 23. The applicants have owned it since 2013. Is that correct? It is under the lot coverage limitation. Current impervious coverage is 13.5%. And again, what's proposed is an expansion of 1.6%, which is well under the 20% that's permitted. Everything else about the application complies with minor variance criteria. It's under the gross floor area threshold for accessory dwellings, and it's under the 20% lot coverage threshold. I would like to rely on the written narrative that we submitted, that the applicant submitted, addressing the variance criteria. I'm happy to walk through those one by one and explain how the application meets those. But in lieu of that, I'm happy to answer any questions about the application or the property. Mr. Bowen is here to correct any mistakes that I've made in addressing this application, and also to answer any questions you have about ownership or the history of the property.
Sure. So, Mr. Bowen, since you're here, and I appreciate you taking the time to come, I went down and visited the property, as I'm sure Ms. Gezzi probably did as well. I don't know about any other commission members. But give us a little history to the building, what you expect to find, what you hope to do. Just a little bit of your own personal, if you don't mind.
I've owned it since 2013. My wife and I actually used to own the property next door, so we've been coming to St. Michael's for quite a while. We like this particular property. It was an absolute project. It was completely overrun in all sorts of ways, and completely neglected by owners who were maybe 3 generations ago. When the original owners bought it in 1930. We were the first owners to buy it since then, but there were 2 or 3 generations that went past, and there was a good half acre of just
I'm not getting anything.
Continue.
There was a complete overrun of the property. The dock was infringing on the neighboring territory. We replaced that. We went through the living shoreline process back in 2013 and 14. We used Bailey Marine, Mark Hill, I think I heard someone mention that earlier. They did a fantastic job with it. We tamed the forest that was there, replanted numerous indigenous types of trees. So this has been a long-term project for us, and so we have ideas. So I have a big family.
It's breaking up pretty bad. I'm not getting everything.
Okay, so I'd ask maybe you pull the mic a little bit closer.
Okay. So, so this is the next stage in the process. So we put sewer in just this spring. So we've made a lot of improvements to the property. We've been good neighbors. Soon, the yacht club is one of our neighbors, and we've got neighbors on either sides as well. I've got a big family and 2 perspectives, just a large number of people and large sizes too. My wife is 6 foot tall. I'm 6'3". My kids are all projected to be 6'4" or 6'5". This guest house, we put people in there, but it's lovingly referred to as the Army barracks inside. It's nice from the outside. It's got siding. It's very genteel. The inside though is fairly rough. I mean, my wife has tried to make it look nicer with paint and so forth, but it's really not up to modern living standards. It's missing a lot of types of normal perks that you would have to expect to see in a house, in which it's not too surprising because it is very old. I think I'm answering your question.
Yes. Yep. Perfect. Yep. Perfect. All right. At this time, I'd ask if there are any comments or questions from the commission. Paul, we'll start with you.
I don't have anything at this point.
Mr. Boycourt?
I have a question about the existing additions. Am I to take from the 2 sheets that we have as the deck and the stairs are going to be removed for the new project?
That's correct. The waterside deck is proposed for removal, and as a result of that, the structure, as far as distance from mean high water, becomes more conforming. I think it goes from 38.8 feet to 30.7 feet, but that deck and the waterfront stairs are proposed for removal.
Thank you. Otherwise, I have no comments. I mean, normally we would get very nervous as we get closer to the water, but with the planning staff making sure that correspond to the replacement versus rebuild versus trashing, all these definitions are properly defined, then I have no problem with it.
Commissioner Dizzy?
I have a few questions actually. On the expansion piece for Ms. DeFlo, can you just help me out in terms of understanding what does expansion entail as it relates to the foundation, the sidewalls, etc.?
The variance in the former code used to be all about gross floor area, but now it is not. It's about.
I'm not getting sound again.
Okay, Elise, is your mic on?
Yes.
Yeah.
So in the former code, the minor variance addressed gross floor area, but in this new code, it's all about lot coverage and maintaining under 20% of the existing lot coverage that's in the buffer. So this project will only increase the lot coverage by 11 square feet.
But I think it's also been our policy in the department that once those walls come down and the foundation is just left, then that structure no longer exists. So any from the foundation up, any reconstruction of that structure, I'm using the wrong word, any work done on a structure from the foundation on up would be a new structure. And that would be not subject to the minor variance process. That would actually be a variance to the Board of Appeals. There have been arguments in the past from, I think, property owners that, well, if I leave the foundation there, the structure still exists, and staff has not ever supported that argument.
I need a new mic, so can I maybe borrow?
Those are set.
So Miguel, this is Bill, I'm a bit confused, so the proposal as stated does not conform to this process criteria.
Well, it does. As they've proposed it, they are proposing to keep 3 walls, but the 4th wall would come down so that they could accommodate the expansion. The expansion's landward from the existing structure, so it doesn't encroach any closer to the mean high water. What the applicant has stated is that during the building permit process, if it's determined that those 3 walls have to come completely down, or because it has to come up to current building code, at any point in time during that building permit process, the building official could come to the planning officer and say, I believe now at this point it's a replacement structure, or it's a reconstruction, it's not an expansion, and as such it will now have to go to the Board of Appeals to be able to continue moving forward. And so we wanted to be sure that the applicant and the staff were on the same page in terms of understanding that, and that's why we agreed on that 4th condition.
Okay, so if the 3 walls are kept, and if the foundation would be expanded, and a new 4th wall put up on the back side, then that is still the qualifications of an expansion. And what if one of those 3 walls, say if 2 of the 4 walls come down, does it also then default back to the major variance in going to the Board of Appeals?
Yeah, those are good questions. We'd have to defer, or we couldn't answer that question until the situation came forward. We would have to really rely on the building inspectors and the building official to help make that determination.
Okay, all right. Then, okay, so we're looking at this as an expansion. That's great. In terms of proximity, I see it's a waterfront property, but there's also a bit of a cliff. It's got some nice topography. There's a bit of a cliff, and then we've had major rain. There's actually a ditch/stream along the side, which is about 15 feet or so, what I could tell, from the side of the property, and that's not really designated in here. And I was just curious why that might be. It comes in, and it actually comes in quite past alongside the cottage, and I just was curious why the engineer hadn't captured that in the drawing.
That's for water runoff. I wouldn't call it a stream. We spent a lot of time getting the water right on the property. So we had to build culverts and build up here and take away from here to get the flow right. So that is between our neighbor, and that was in conjunction with my neighbor who also had issues with inundation of her land. So we made that so that it flows out to the water when there's rain.
Okay, so
We had a large amount of rain yesterday, and there's
a lot,
it's-
5
it's-
inches.
Yeah, it's contained, and it's not a lake or running water, it's for runoff.
Okay, so it's not even, that's why the engineer did include that on, because it's not considered a stream. Okay. And then my last of 3 questions is notification. I noticed there was no signage up, and typically on something like this, don't we have signs? So I wanted to defer again to Mr. Flo about signage as well as notification to neighbors. What is required in this, and can we be sure that that notification was provided?
The posting of the property with a sign is only required for the major applications. I've looked through the code, and in the subdivision section and the site plan section, it specifically tells you when the property is posted. But with this minor variance, it does not indicate that the property needs to be posted.
Okay. We had a matter earlier, and I don't know, it's just a different type of a matter perhaps, that they had a sign posted. And
Yes.
that's one of the things that kind of
Well,
triggered my...
Chapter 20 of the Talbot County Code directs Board of Appeals applications to be posted with a sign.
Okay, all right, great. All right, thank you very much. That's all I have.
Commissioner Stranahan?
All of my questions and concerns have been asked and answered. Thank you.
So I guess this probably isn't really a question, more of a comment. But Mr. Mulaney, I guess, and this again is between you and your client, if I were the property owner and I had a building that was built almost 100 years ago, I would almost ensure that it probably, I would think about replacement as opposed to expansion. So my fear for you is that you get in this project, leave 3 walls, take 1 down, realize you have serious problems, and then run into a problem somewhere with a neighbor, Board of Appeals, size, on and on and on. But I just want to make sure you realize that is a risk that you and your client are taking. That, you know, what is before us today is what we will vote on, but I just want to make sure your client realizes the consequences, in my opinion, that could arise later.
Understood, and we've had discussions internally with the architect and contractor and believe that there is flexibility to keep those components. The property owners did not want to propose a monstrous expansion to the house and felt that the minor variance was applicable for an 11 square foot expansion of an existing structure. Didn't want to get greedy, and frankly, I don't believe they want to build something that is much larger than what's on the property today. They just want a structure that their family can use moving forward. But we understand and understand the condition imposed by staff and the condition that will be imposed by your recommendation.
Yep, understood. Good. Okay, at this time, I'll ask if there are any questions or comments from the general public.
I have one other question after that.
Anybody on the call, if they would like to comment on this application, please let us know.
How do you let you know?
I'm sorry? Would you like to comment on the application?
I am online. Thank you. Didn't know how to let you know. This is Leslie Steen.
Oh, Leslie, hi, thank you. We're actually on the Yacht Club Road minor variance.
Yes.
Would you like to
Yes.
comment on that one?
I would just like to comment and let the Planning Commission know that this is a licensed short-term rental. Just realized it as the commission was considering it.
So, Mrs. Steen, we're going to let the applicant speak to that. But my understanding is that they used to own the property next door, maybe they still do. I think it may be a short-term rental, I don't know. But I don't think this is, but again, we're going to defer to the applicant and his agent to address that, so.
Okay, thank you.
Thanks for your comment. There are two houses on the property. There's a main house and then there's the guest cottage, which is the subject of the hearing today. There is a short-term rental application that's been approved on the main house, and it's specifically excluding use of the guest cottage. So there is no short-term rental on the guest cottage.
Okay, I stand corrected. So, yeah, okay.
On the, well, I don't think, does that impact, I mean, in terms of our rules and regs, that doesn't really impact the actual structure.
So
doesn't it?
my opinion is it would not, if something did come up later before the short-term rental review board, that would be something before them. And I think this is a structural thing. However, I do appreciate you bringing that out, Mrs. Steen. I was aware of neighboring property that was, but I was not sure that this one was. Yeah.
From a zoning perspective, my other question, sorry about this, I'm assuming that there's no height restrictions, correct? This is a two-story structure, it's going to be close to the water, there's no height restrictions in our zoning ordinance, correct, Mr. Phil?
We have a 40-foot height limitation.
Is your mic on?
Yes.
But this would be well under that.
Accessory structure might have to be under that.
No, I think it's the same.
Okay.
Mrs. Steen, we'll get back to you. We're not done. We had another question that came up, so.
Residential accessory buildings on lots larger than 2 acres, 30 feet.
Stand corrected.
Okay.
190.12.1.
Does that answer your question, Ms. Hazel?
Yes, it does, thank you.
Okay, Ms. Steen, back to you. I wasn't sure that you were finished. We did clarify that the main house had an application for a short-term rental, but the guest cottage, or whatever you want to call it, at this point does not. Did you have any additional question or comments on that?
I noticed the same ownership name, and I'm aware that there are a number of neighbors in that area that are very upset about short-term rental in that area, and I just wanted the commission to be aware of that.
Yeah, thank you very much. I actually did notice that on the way down, that I did see some signs, so yep. Thank you, Ms. Steen. Yeah. So are there any additional comments from the general public? Okay, hearing none. Any additional questions or comments from commission members? Okay, hearing none. Miguel?
Just for the record, Mr. Chairman, I believe for dwellings, including accessory dwellings, I think the height is 40 feet. I think other residential structures are 30, but just for the record.
Okay. Yep.
And in any event, the cottage has expanded, will comply with bulk standards, including height restrictions for the property.
Very good. Thank you. Okay. At this time, we will entertain a motion.
Okay, I move that we approve the minor variance for the project on 24700 Yacht Club Road, St. Michael's, Maryland. All staff conditions being complied with.
Okay, we have a motion. Do we have a second?
I'll second that.
Okay, we have a motion by Commissioner Stees, a second by Commissioner Gezzi to recommend a favorable, that the planning officer approve the minor variance for Yacht Club Road LLC. Miguel, will you take the vote?
Mr. Boycourt?
Aye.
Mr. Spies?
Aye.
Ms. Gezzi?
Aye.
Mr. Stranahan?
Aye.
And Mr. Council?
Aye.
Motion passes 5-0.
Thank you very much. Good luck with your project.
Thank you.
Okay. Next on the agenda, applicant Talbot County, Maryland, agent Mary Kay Verdery, planning officer, requested a recommendation to the county council, resolution number 291, and I assume that the county attorney, Tony Coopersmith, will be handling this, Miguel. Do you want to give an introduction to it?
Tony, would you like to handle it? Do you want me to do an introduction?
Would you mind doing an introduction?
I will do that, and of course Tony's available as well. I'll give this a shot. There are 3 items in your packet. The first one is Resolution 291, which is an annexation of the Covington property, which is located at 29328 Dutchman's Lane. That property is, that resolution would annex the Covington property into the town of Easton. That property is currently zoned town residential. Once it's annexed, the residential lot, which is improved by the way, would be rezoned to R-10A under the town's zoning district. The second item is for informational purposes only, but it's critical to why this is all packaged together. It's a transfer of a portion of Dutchman's Lane to the town of Easton. Currently, the town of Easton does not own that section of Dutchman's Lane, which generally that section is from where the start of Easton Club East and then going west to Route 50. That would transfer over to the town of Easton for ownership and maintenance. And then Bill 1462, which is a bill to de-annex a parcel known as 3rd Street, which is along Route 50. That currently is in the town of Easton with the designation of R-10A. Once that portion is annexed, staff is, the county zoning designation would be split zone, which I'll continue on about that in just a minute. Most of you, if not all of the commission members, know that there's something called the 5-year rule. So for when any property is annexed, say from the county into any of the towns in Talbot County, those annexations must result in the mapping of town zoning similar to the existing county zoning. If the zoning that would be applied by the town would be substantially different than the current county zoning related to uses and density, then the annexation of that property is subject to the 5-year rule. So for a period of 5 years, the uses and density have to remain consistent with the county zoning unless the county council waives that 5-year rule. So in the staff report that you received from Mary Kay Verdery, staff has applied an analysis of the, this is for the Covington property, that property which is proposed to be annexed, that's adjacent to Dutchman's Lane. Staff provided an analysis or comparison of the current TR zoning in the county to the town's R10A zoning. We looked at, when we compared the two, we looked at the density and intensities of those two districts. We looked at the land uses that are permitted within those two zoning districts, and we looked at something called the 50% rule, which is required to be reviewed as part of the annexation 5-year rule, which is that development density wouldn't be greater than 50% than what's allowed under the county. And then we also looked at the comprehensive plans with the county and the town. And through that analysis, staff determined that that the TR zoning and the town zoning would be substantially different. Staff's recommendation on page 6 of 6 for resolution 291 is that although the property is located with the town priority 1 growth boundary, that given the substantial higher densities and inconsistencies in certain land uses, staff advocates that the planning commission favorably recommend the zoning waiver request to the county council. As I mentioned, resolution 292 is for informational purposes only, and so no planning commission action is needed on transferring the ownership of that section of Dutchman's Lane over to the town. And then staff's recommendation on Bill 1462 is that de-annexation, which essentially is what's happening with 3rd Street, and the reason why we have to do that de-annexation is to not create a separate enclave. Once that transfer is over to the town, it creates that enclave, separate enclave in the county. And so by de-annexing, if that's a word, 3rd Street, it'll actually create that connectivity. So that de-annexation is not subject to a 5-year rule. That's only for annexations. And the zoning code doesn't define a process for de-annexation. But using the factors that we considered for the map amendment process in section 190-55.2, staff advocates support for and a favorable recommendation of the county council on Bill 1462. There are some maps that you have attached to the staff memo, which show you the general area as well as an aerial of the area, and shows you the section of 3rd Street that would be de-annexed, and shows you the Covington property that would be annexed to the town, and also the section of Dutchman's Lane, which would transfer from the county to the town of Easton.
Tony, is there anything that you would like to add?
Mute whomever is making all that noise.
It's one of the commissioners.
Oh.
We're getting a little bit of feedback from somebody on the call. It might be maybe you're outside, it might be wind or something, but just so you know.
Tony, are you still with us?
Yep, I'm here.
Okay. Would you like to add? Yep.
Yeah, sure. I can hear you, Chip, very well. I can hear Miguel very well. I can't hear if anybody else is making comments. But yes, Miguel, thank you very much. I think that's a very good summary of things. The whole purpose of this project is that the county and the town of Easton both desire to transfer Dutchman's Lane, a large portion of Dutchman's Lane, that is, from the county to the town. And that sounds pretty straightforward. You think, okay, well, how about we just, prepare a deed and give it to them? It's a bit more complicated for a number of reasons, and mainly because the road had to be brought up to town standard, and the town wanted the road annexed into the town in order to agree to take it. So the annexation is what we're dealing with here that makes this all a little bit more complicated. So there's 3 parts to the transaction. There's the annexation, there's the de-annexation of 3rd Street, and then there's the transfer of the road itself. The annexation includes the road, but it also has to include this Covington property. And if it didn't include the Covington property, then we would have an enclave, excuse me. And so that's why we have the Covington property. And so Mr. Covington, the owner, is a co-applicant with the county for the petition for annexation. And then the de-annexation piece is that if you do the annexation of Dutchman's Lane and the Covington property, you then have to de-annex this street strip of ends. So you would create an enclave. So there are two enclave scenarios. And then the final piece of the whole transaction is the county authorizing disposition of the roadway itself to the town of Easton. So that's the transaction, basically.
Okay. So I'm assuming that part of our determination is that this is consistent with the comprehensive plan. Does that need to be part of our motion and recommendation to the council if we were going to vote to approve this?
I am not aware of a consistency requirement, although that's always something that makes sense to look at and to think about. I believe that the two pieces of business, two pieces of legislation that are really before the commission are the waiver of your hold and the rezoning of 3rd Street or the zoning of 3rd Street. And so for the first one, for waiver of the 5-year hold, I mean, Miguel delved into that. I don't know if there's a consistency finding that is made there, because I think the assumption is that it's already been annexed into the town. And so then it's a question of going from the county's zoning district to the town's zoning district, which in this case, they're both residential. The town district allows slightly higher density. So I guess you could look at consistency with the comp, and though I don't know that that's technically required under the statute.
Yep, understood. Yep, okay, thank you. Yep, good.
Yep.
So at this time, I'd ask if there are any questions from the commissioners. Paul, are you still with us?
Yeah, I don't know the town zoning that much, but just to clarify again, is the zoning that they're asking for the 5-year waiver pretty similar, or is it, I mean, what are the differences?
So,
I think it's mainly the differences in density, but maybe I'll defer to Miguel, because I think the office did an analysis of all the different uses for it. And I should clarify that the Covington property, I think, is 1.9 acres, and it's already improved with a single-family residence on it.
Yeah, that is correct. Tony is correct. The major difference is in the density. The maximum density in our zoning on that property is 1 acre without sewer, which currently it's without sewer, and it's not also designated. It's not a parcel designated in the county water and sewer plan. The town's R10A zoning is 3.5 units per acre. There's a difference in lot size too. Our zoning district is 1 acre without sewer, and theirs is 10,000 square feet. I think the land uses, when you compare them, many of the land uses are allowed in both zoning districts under different entitlement processes, but it's the density and the 50% rule.
very good. Paul, anything further?
No, just to follow it up, to say I'm comfortable with it. Most of the time, we kind of use that 5-year plan to maintain some kind of control if it's a major project, or make sure that there's not major change or negative impact on the community in a short amount of time. And kind of with this project and the scale of it, that's really not a concern of mine.
Great, very good, very good. Mr. Boycourt?
Yes, I mean, I don't want to date me here, but the ancient comprehensive plan discussion with the town, this is 2 comprehensive plans ago, I think. We went around and talked to all the towns, and I was, just as a side comment, very pleased that all those discussions went remarkably well. And at the time, we were trying to create what was awkwardly called a countryside preservation area, but this area here, and a lot of the town observation, the zoning, a lot of the zoning was planned with individual municipalities, in this case Easton, with the expectation that they would work with this territory in their interest. And I think this is a very clever solution that Tony just talked about, the difficulty of making it all work. I think it's a very clever solution to solving the problem of what the town intends, and the county. I don't think the county really has any major concern here that it follows. The zoning is different, but it's not substantially different in my opinion. I think this is fine, and I think that we ought to go with it.
Sure. Ms. Gessie?
Yeah, for my own edification, because this is my first exposure to a 5-year rule, I just would like to restate so I'm sure and understand. The Covington property is owned currently, or not owned. It's within the county zoning area, and as is Dutchman's Lane, and so those are going to be turned over to the town of Easton, correct? Okay. And had we not had the county not turned over the Covington property to the town of Easton, it would be its own enclave because it would be a sole property with a front of a county road and around it county land. I'm sorry, county road. It's going to be, it's a little confusing. The Covington property, had we not made it part of Easton, it would still be county, and it would be fronted by a Easton road and Easton property around it, hence creating the enclave. Is that correct?
My understanding.
Okay. And then the other enclave, the 3rd Street, had 3rd Street not been de-annexed, turned back into county land, that would be separating this strip of county property along Route 50, and that small little square, which is also Easton's property. So that, I don't see how that one, I don't see how it's an enclave, and 2, how that fixes it, other than making it one bigger rather than 2 pieces. Or maybe that's not the enclave that you were referring to, Mr. Cooper Smith.
That is the second enclave that would be created. So if you annex the Covington property and Dutchman's Lane into the town of Easton, then if you did not then de-annex that 3rd Street pipe stem, then you would have a second enclave that would be created, and the pocket of enclave would be county land surrounded on all sides by town land, and the north part of that pool of county enclave would be Dutchman's Lane on the top and the 3rd Street pipe stem on the bottom.
Okay, that makes sense. So the enclave would be that I'm looking at the PowerPoint current that's entitled Current Zoning, Ocean Gateways running through it, and it has the 3rd Street in white. So the white separates the north from the south. So the enclave would be that gold solid area. Is that correct?
I don't have that exhibit in front of me.
That is
correct.
All right, yes.
Sorry, go ahead, Miguel.
Okay, very interesting. All right, it makes sense. I think you guys have put a lot of work into it. The other question I had regarding the letter from Planning and Zoning at state level, I had interpreted, and maybe I interpreted incorrectly, was that they felt that the differences between the county and the town were fairly close and consistent. And I'm referring specifically to page 3 of 6, and that's in Mr. Boyd's letter from the Maryland Department of Planning and Zoning at the bottom. It says the proposed municipal R10A district appears to be consistent, underlined, with the county's TR district from a density perspective. So I was a little confused by that.
Yes. we didn't agree with that assessment because the coveted property is not in the water and sewer plan.
Okay.
That when we look at the density for the TR zoning district without sewer, that the difference is substantial.
Okay,
You know,
that makes sense. Okay, great. Thank you, Mr. Summaries.
Anything further? Commissioner, anything?
I think we've covered things pretty well. It's one of those fairly tedious matters that I think the staff has done a really good job in bringing all the information we need to us. Thank you.
Very good. Any comments or questions from the general public?
hold on a sec here.
Yep.
Any comments from the general public on bill number 1462 or resolution number 291?
Okay, hearing none, at this time, we will entertain a motion.
I'll move.
Mr. Chairman, I don't hear it. If there's somebody else ready to make a motion, if not, I will.
Okay.
Go, Bill, I'll second.
Okay. Mr. Chairman, I move that we recommend to the county council a waiver of the 5-year rule, the hold on this proposal to rezone the property 29328 Dutchman's Lane, from town residential to the town's R10A zoning district upon annexation.
Okay. We have a motion.
Second.
Okay. We have a motion and a second to recommend that the county council pass resolution 291, which would waive the 5-year hold in accordance with local government article 4-416 of the Maryland Annotated Code. Miguel, would you take the vote, please?
Commissioner Boycourt,
Aye.
Commissioner Spies,
Aye.
Commissioner Gezi,
Aye.
Commissioner Stranahan,
Aye.
and Commissioner Council.
Aye.
Motion passes 5-0.
Okay. Now, Miguel, on resolution 292, do we need to take action?
No action needed on that.
Right, okay, I want to make sure, okay? So next would be, we will entertain a motion on bill number 1462, which would repeal the zoning map, map 34 of Talbot County.
Mr. Chairman, I move that we recommend the county council repealing the zoning map 34 to specifically to DNX 3rd Street as named from the town into the county and with a new tax map designation.
A second.
Okay, we have a motion by Commissioner Boycourt, a second by Commissioner Stranahan to recommend that the county council favorably pass bill number 1462. I can't say it quite as eloquently as Bill did, so we're going to go with his motion. Miguel, would you call the vote?
Commissioner Boycourt,
Aye.
Commissioner Spies,
Aye.
Commissioner Gezi,
Aye.
Commissioner Stranahan,
Aye.
and Commissioner Council.
Aye.
Motion passes 5-0.
Okay. Next, we have discussion items. Miguel, do we have anything for discussion today?
No discussion items.
Okay, staff matters.
Just that Jen passed out an article on large lot housing popping up across Pennsylvania farmland for your own information.
Great. Saw that in email from Mr. Watson, and I think he said thankfully Talbot County doesn't have to deal with this, so I would defer to that as through the guidance and foresight of Commissioner Boycourt. So we'll give him credit for that one.
And perhaps we could do some of the things Pennsylvania's doing.
Great, great, yeah.
The other item I wanted to bring up was our future meetings. Doesn't seem like things are going to end soon in terms of our need to do virtual meetings to allow both the planning commissioners as well as the public to be able to have the option of participating in our meetings either through live stream or by calling in. And so my recommendation is that we continue to meet, at least for our September meeting, that we meet here in the Y Oak Room. I think we're comfortable with the setup now, and not just physically the setup, but also technology-wise. And that we'll look into reserving the Y Oak Room through the rest of the year, and maybe make a decision each month whether or not we want to continue to stay here for the following meeting or whether we want to go back to the Bradley Room.
I would be happy with that.
Yep.
Yes.
Yep, so, okay, so that's what we'll do. So we will have our September meeting here at the community center in the Y Oak Room. So good. Thank
That
you
is
for that.
confirmed. Jen, we have that reserved already, I think.
Yeah, great. Okay. Work sessions.
No work sessions.
Okay. We had talked about, based upon what the county council does, perhaps having a work session with planning commission. I wonder if we could go ahead and set that up. And if the county council votes otherwise, then we could just cancel it, but at least get on their agenda. And I would prefer to do that sooner rather than later, just because, once we get into fall, I know a couple of us are going to be a little bit busier, so I don't know if it's too late to get on there. August, I think they meet the third week of the month or something. But anyway, if we could get on an agenda sooner rather than later to talk with them.
With their planning commission, correct?
I think that would be best to start with.
And to see if we can get on their agenda?
Correct.
Okay.
Yeah.
All right.
Yeah. Or if they want to come to us. I mean, I'd extend the olive branch, and it's their project. I think we could. I'd be willing to go to them. I don't know how everyone else feels.
Okay.
Yep.
All right.
Okay.
I'm happy to do whatever.
Yep.
Yes.
Yeah. Okay. Commission matters. Anything for the good of the group? No. So Tony, are you still on the line?
Yes, I am.
Okay. So this is a question, and it's more for future reference than past. On the short-term rental issue that we dealt with last month, and that's why I asked about consistency with the comprehensive plan. So when we had a recommendation, I guess, to what I would consider would be a change to Chapter 190, the zoning ordinance, in regard to short-term rentals. In your view, does the Planning Commission look at what is in front of them and say it is consistent with the comprehensive plan, or is your opinion that the Planning Commission should make recommendations to the zoning ordinance itself in that case?
Sorry, say that last part of the statement again.
Okay, so basically on the short-term rental issue that came up last month, the Planning Commission voted to recommend favorable approval of that bill, but we offered amendments to that. So my question is, in an issue like that, should we just confine consistency with the comprehensive plan or not? Or when it comes to zoning matters in Chapter 190, should we have the ability, or do we have the ability to offer possible amendments for the county council to consider?
Yeah, so this is always a little bit of a tricky area in the sense that our office represents both the county council and other bodies such as the planning commission. Let me just try with an example. The Board of Public Works when they were considering the Lakeside project. They had the same question come up, and it is a gray area in the sense that you probably technically have the ability under the charter, the county charter, and the county code to make, you know, whatever recommendations you all think are appropriate. I think the Planning Commission's job description in general includes making recommendations on zoning amendments and things of that nature. As a practical matter, though, I mean, how far do you want to go with, you know, trying to lead the county council when they are the ultimate decision maker? And so if the county council gives the Planning Commission something and says, will you please look at this and make a recommendation on it, it raises the question, and this is every time this comes up almost, are we just giving an up or down, thumbs up, thumbs down on what the council has given us, or are we, if we give a thumbs down or a partial thumbs down, should we offer something that we think would work or would make sense? And, you know, sometimes the Planning Commission is going to do that and the council is going to say, great, thank you so much for doing that. Other times they're going to say, why'd you do that? You know, that wasn't, you know, what we wanted you to do. We just wanted you to give us a thumbs up or a thumbs down. So it you know, I think it's just one of these things that is a little bit of a gray area, and but I think ultimately the commission is empowered to offer whatever recommendations it thinks is appropriate. You know, how you exercise that discretion, though, is the question.
Okay, I think that answered my question. So my next question is, when we advertise in the agenda, those matters where we recommend to the county council, make a recommendation, should the agenda request be, instead of just saying recommendation to the county council, should it say in those specific agenda items, recommendation to the county council on consistency with the comprehensive plan? In other words, I think some of this might be somewhat confusing to the public that looks at the agenda.
Right.
And quite honestly, some of it might be confusing to me as well. So I'll take partial for that. So does that make sense, or does that?
Yeah. Well, I think what's the tricky part about it is there's certain times when the Planning Commission, under the state law, has to make a consistency finding, and so. That Lakeside project, for instance, where you have a comprehensive water and sewer plan amendment, it specifically says in state law that the Planning Commission has to make a finding of consistency, and then it has those factors that are listed. And so in that case, the agenda, I think, would certainly say, you know, for consistency finding with XYZ comprehensive water and sewer plan amendment.
Yep, perfect.
For more general recommendations on pieces of legislation, like, for instance, the recommendation that you all did on the bill for giving a zoning designation to 3rd Street from today, to me, historically with the Planning Commission, it's been more of just a recommendation, and that could include in it some comment on consistency with the comprehensive plan, because, you know, really all of our zoning actions should be consistent with the comprehensive plan. But what's not totally clear, and I'd have to probably do some more research, is, you know, every time the Planning Commission makes a recommendation on a zoning matter, does it have to go through all of those factors? I mean, historically, the Planning Commission has not done that, so that would be new. The Commission's really only done that with water and sewer plan amendments. And comprehensive rezoning efforts. For these more ad hoc zoning changes, like with the short-term rentals, we've not historically gone through all of those elements. So I think that we would probably, for now, just stick with what we've always done, which is if it's a comp water and sewer plan amendment, let's put a consistency finding on the agenda. If it's something broader than that, like the STR, it's a recommendation from the Planning Commission to the County Council on that proposed legislation.
Very good. Yep. Okay, that's what I thought the Planning Commission, we should review that and make sure that we're staying within our sandbox. Yep. Okay.
Right.
Yep. Okay. All right.
Okay.
Any other matters to come before the commission today?
Just to I want to inform the commission that I missed the webinar yesterday that I signed up for called Parking Reform Made. A very exciting one. I'm sorry I missed it. I'll gather some of the reports from that. It was some kind of webinar that was suggested to me. I'll come back to the county with the report.
I was on that, Commissioner Boycourt, and I think they are going to get out the recording of PowerPoint on that.
Oh, great.
To people who signed up, so we can, make sure that we communicate that with the commissioners.
That'd be very good.
That'd be very helpful.
Good. Very good. Yep. Thanks, Bill. Yep. Okay. If nothing else, I will entertain a motion to adjourn.
I motion we adjourn our meeting for today.
Okay, we have a motion to adjourn in a second, so we'll go ahead. Do we need to call the vote on that? I don't know if we ever have.
Might as well.
Yeah, we're just going to go ahead and adjourn at 5 after 11.
5 after 11? Yep.
Yeah. Okay. Thank you very much.